Welcome to Tennessee Real Estate Insider. I'm your host, Allyson Spencer, top producing real estate agent in East Tennessee and property manager. Today joining me is Derek Malcolm. Derek, thank you.
Thank you so much for having me.
I'm so excited to have you today because you are an expert at probate. And we are going to talk about what happens when a home needs to be sold and it's going through probate.
Absolutely.
Okay, so let's dive right in.
Let's do it.
Give us a brief overview, kind of what happens when this issue arises and what process takes place?
Absolutely. So a highline level, sort of a bird's eye view, a probate is just the process of administering someone's estate once they've passed away. Every state has different statutes that dictate what that process has to look like. And that process can be different depending upon, did the deceased person have a will? Did the deceased person not have a will? And if they did have a will, what does it say? What are some of the provisions of the will? So all those can determine what that process has to look like, what type of probate has to be done. They're not bad in Tennessee. Tennessee and Virginia, we're pretty lucky. There are some states where probating is super complicated. California, for example, people will put everything they own in a trust because they want to avoid what is a complicated probate process. In Tennessee and Virginia, it's not a complicated process. So a lot of people are afraid of it, but it's pretty simple here. It can be quick, it can be easy, it can be done relatively cheaply. For purposes of dealing with probates when you have a house involved, for us, that's typically the issue. The issue is this person wants to sell their house, mom and dad have passed away, so what type of probate is needed for this particular purpose? And that sort of changes the analysis a little bit. If you're probating because somebody has bank accounts that you can't access, then that's sort of a different process. If you're probating maybe because somebody has tons of heirs and there's property in multiple states and they have bank accounts and investment accounts and personal property and all of these things, that's a different process. But for us, it's almost always just, hey, what do we need to do to get this real estate sellable?
Right.
And the good news is, because we're only focused on the real estate part of it, it can make the process a lot easier. Mm-hmm. Sometimes, given the situation that the deceased person was in financially when they passed, a full probate is still necessary.
Okay.
And a full probate just is, it's filing a series of documents with the court. If there is a will, the court will approve the will, they'll record the will, they'll appoint somebody, an executor of the estate, to sort of take charge of the deceased person's assets and then start distributing them pursuant to the terms of the will. If there is not a will, probate sort of looks the same, except there's just no will to record. The court will appoint somebody as a personal representative of the estate to do the same thing, collect all the assets and distribute them per the state and Tennessee statutes. But that's a full probate. And if we can avoid that in the real estate process, we want to try to avoid that, because that's not a long process, but it's longer than what we need to just do sort of what I call a real estate only probate. If somebody died owning real estate and the family's trying to sell it, if we're not having to do a full probate, we have two options. If the person died without a will, it's very easy. We just have to get somebody to give us information about the family. When this person died, were they married? Did they have children? Did they have any deceased children? If they didn't have children, who is their next of kin?
Right.
We find that out, we put it in an affidavit form, and we get somebody who does not benefit from the sale of the house to sign that affidavit. Okay. A neighbor, a distant family member, somebody that they went to church with, something like that.
Okay.
If there is a will, we can do what's called a muniment of title probate. And that is a probate for the sole purpose of recording the will so the real estate can be sold. Much faster than a full probate, much less expensive than a full probate. So in the real estate context, those are usually our two options. And that's our first question. Is there a will?
Right.
Or is there not a will?
And this is generally if the sole owner of the property passes away. If someone is married and their spouse passes, it doesn't have to go through that because their spouse owns the home and we can proceed with the sale without a delay.
Correct.
But if the sole owner of the home passes away and it goes through this process, how many months does this usually take?
So there's a couple of different timelines to think about. There's a statute in Tennessee that says if a person has passed, you really can't sell their property for 60 days. The reason for that is if somebody before they died, if a week before I die, I say, Allyson, I want you to have my house. and I give you a deed to my house, but I say, don't record this until after I'm gone. Well, that type of pocket deed, people still do that. People do that as an estate planning mechanism. And so the 60-day window gives somebody a chance to get that pocket deed and record it. So,
wow.
yeah.
That is very enlightening.
And so, yeah, so 60 days. Now, there's an exception for that. If a person is already under contract and then they pass away during the pendency of the contract, we don't have to wait the 60 days.
Okay.
The presumption is they've not given anyone a deed outside of this context, or they wouldn't have signed a contract to sell the property to somebody else. So if they're already under contract, we don't have to worry about that. But that's the first timeline. Is typically if somebody dies, we have to wait at least 60 days to make sure there's no unrecorded deeds out there that somebody comes back and records. The big time frame is creditors' claims. In Tennessee and in Virginia, a creditor will have 12 months from the date of death to file a claim against a deceased person's estate. And so we have to do closings sort of in conjunction with those deadlines. What makes that confusing is there are things that can change those deadlines. If you don't do anything, that 12-month creditor claim period is going to be the full 12 months. If you do a full probate, not the real estate muniment of title probate, but a full probate, part of that process is the court publishes a notification in the newspaper to notify creditors that this person has passed. If you do that, it takes that deadline from 12 months from the date of death to 4 months from the date of publication. So we've substantially shortened that time frame.
Wow.
There's also a statute that says if after 6 months, no probate has been filed, no executor has been appointed, the property can be sold to a third-party purchaser for value, and it won't be subject to any creditor's claims. So you also have this weird little 6-month time frame that can apply. Those are all very, very fact-specific. So the easy thing for those is just chat with us. But it's hard to remember all those time frames.
Right.
It's hard to, but what we have to remember is the creditor's claim period expires. Let's talk to the title company about what mechanism we might want to use to see if that can be shortened. Maybe we want to do a full probate, even though we don't need to, just to shorten that creditor's claim period, because that means we can get our money faster.
Right.
Now, that doesn't mean that we can't close for 12 months. It doesn't mean we can't close for 4 months or the 6 months. We can close. We can pay off any mortgages on the property. We can pay property taxes owed, agent commissions, title company closing costs. Everything can get paid except the sellers of the property, who are the beneficiaries or heirs of the deceased person.
Right.
Everything else gets paid. Their share, their net proceeds just gets held in escrow until that creditor's claim period has expired.
Right. I do believe, I think we had a deal together where that was the situation. Now that I'm remembering this, and their proceeds had to be kept for a while. So that's good to remember for people who are rushing to sell the property. They may not have to rush.
Absolutely.
It can, because they're not going to get the money right away. So if they have plans for that, it needs to wait.
Absolutely.
What about home valuation or court-ordered sales? How does that come into play?
So typically a court-ordered sale is going to come into play if there's a will. So we talked about the specific language of a will can dictate how the process will go. When most people prepare a will, they say, I leave my real estate to Allyson. Well, that's clear, and it's a clear devise of that real estate to you. And so what that means from a legal perspective is when I die, it's yours. The will says, I leave it to Allyson, it's yours. Some people don't do that. Some people say, when I die, I want my real estate to be sold by the executor, and I want the money divided 5 ways to go to these 5 people. That's different. The will didn't specifically leave the real estate to a person. It left instructions for the executor to sell it. So that's typically the first thing we look for in a will. Does the will actually make an unconditional devise of the property to the beneficiaries, or does the will instruct that it be sold? Now, people get confused because wills will also say, I give my executor the power to sell any property. Well, yeah, because that's a power that an executor has to have to carry out his or her duties as administrator of the estate. But that's not the same thing as saying, I order you, I direct you to sell my real property and divide the proceeds among these 5 people.
Right.
That's a very specific thing. So we'll look for that. If the will is set up that way with specific instructions for the property to be liquidated, sold, and the proceeds divided, then you're going to have to do a full probate at that point. And you have to be, the executor has to get approval by the court, has to be appointed, has to get letters testamentary, approving them as executor, as personal representative. And then oftentimes the court will want just a little presentation of the facts. Hey, we're selling this property, we're selling it for this much, here's the contract that we have. And sometimes the court will ask, hey, what is market value of this property? Now, the court doesn't typically get too invested in that, as long as typically it's tax value, that's all they care about. But sometimes that comes up because, for example, the will may say sell the property and I want the proceeds to be given to my 5 children. They happen to be minors. Well, the court wants to protect them. So the court's going to want to make sure that the executor isn't just fire selling the property just to get rid of it. The court wants to make sure the executor isn't selling the property to her boyfriend for pennies on the dollar who's going to turn around and flip it 6 months from now. And so sometimes the court will say, hey, look, let's confirm that the property values are correct before I approve this sale. But usually, as long as it's tax value, they'll approve that. That's typically one of the few scenarios where you have to get a court approval, court order to sell a property. Otherwise, most of the time, the will leaves it to somebody. If there is no will, then it's who does the statute say are your heirs if you pass? That's usually your spouse and children. If there's no spouse and no children, parents and siblings. There's sort of a whole series.
And as far as documents go with listing a property that's under probate, who do you find typically is required to sign those documents?
So the best thing for listing, and this is why this sort of is going to get into some tips and things. We need to have this conversation before the property is ever listed.
Right.
I've seen all sorts of sales where one person has signed all the listing documents. Maybe one person has even signed all the contract documents, and that person will say, well, I can sign because I'm the executor. Well, even if the will says that you're the executor, if you've not been approved by the court, you have no authority to do anything. But people don't know that. But what they see is, okay, well, mom died and she left me executor, so I can sign all this. Probably not.
Right.
But they sort of bully us and agents into thinking, you know, I'm not arguing with you over this. I'm not going to hire a lawyer. The will says what it says. Well, you've got an ineffective listing agreement. You've got an invalid listing agreement because it's not signed by all the people.
Right.
So what we need to do, anytime we think that there's going to be probate issues involved, we sort of need to have this conversation on the front end. And we need to know, okay, first question, did the person have a will? And maybe even going back to your point, if the property is owned by a husband and wife and only one of them has passed, there's probably no need for probate at all because the survivor of them is the surviving tenant by the entirety. That's not a probate situation. But we can look at the deed and in 10 seconds know you're good, there's no probate issue. But if there is a probate issue, first question is, did this person have a will or did they not have a will?
Right.
If they have a will, we need to look at it. We can look at the will and see who are the beneficiaries, who are the devisees of this property. Those people need to sign a listing agreement.
Okay.
They all own it.
Right.
They all need to sign the listing agreement, any contracts, any amendments or addenda, all closing documents, everything. If there's not a will, then we need to have that conversation with the family about, okay, was this deceased person married at the time of their death? Did they have children at the time of their death? Did they have any children who predeceased them?
Right.
We go through that analysis to figure out, in the absence of a will, who are their heirs at law? And once we know who their heirs at law are, those are the people that need to sign the listing documents, the contract documents, the closing documents.
Awesome. Now, last question. I know this is a lot of information, but for someone who's trying to be proactive and plan ahead, how would you suggest, if they have a parent or loved one who is at the end of life and who owns a home, what would be the easiest transition for them while they're living to prepare for that?
So a lot of things can affect that. There are certain financial and tax consequences to transferring property. There are certain benefits of transferring it prior to death. the beneficiaries, the kids own it. They don't have to deal with probate at all. But there are certain consequences to that too. One of those is a tax consequence. If you inherit property, you get a stepped up basis. So what that means is that if you sell property that's subject to capital gains tax, when you start thinking about capital gains tax, the very simple calculation is, how much did I sell the property for? Minus my tax basis, which is effectively how much did I pay for it. What's left over is how much I pay capital gains on. When you inherit property, you don't pay anything for it. If I give you a quitclaim deed to my property, you've not paid anything for it.
Right.
So your basis is zero, which means you would have to pay capital gains on the full sales price. But if you inherit property, the tax basis can be the actual value of the property at the time of your parents' death, which means if you inherit it, as opposed to getting them to deed it to you, you can actually avoid, in most cases, avoid all capital gains taxes. There's huge benefit to avoiding all of that. But sometimes there are situations where it might not be worth avoiding the capital gains tax. It might not be, there may be other situations that override the tax basis, the stepped up basis, the capital gains calculation. And so I think the tip for that is, if you're in an end of life situation, it's going to be very fact specific. If your family has a family attorney or a family CPA, I would chat with them. Is there a benefit of getting this out of his or her name now? Is there a benefit of leaving it in his or her name and just letting us inherit it? If you have the benefit of some time, meeting with those people will let them have the opportunity to go through that fact-specific situation and advise them, hey, in this situation, based on these circumstances, here's what I think you should do.
I love that. Thank you so much.
Yeah.
This was such an informative episode, and appreciate you for being here today.
Well, thank you so much for having me.
And tune in next time for our next episode. Thank you.